Okay, so today's topic, Social Security overpayments and debt recovery. Peter Sutherland, co-author of the Social Security and Family Assistance Law and convener of the Legal Aid Clinic at the ANU School of Legal Practice, will be speaking to us about social security overpayments and debt recovery. So this is a really great opportunity for CLC workers to get across recent developments in this area, and there'll be plenty of opportunity for you to engage with Peter and to ask questions at the end of the webinar. So today's webinar is delivered in partnership with the National Social Security Rights Network. Okay, so I'll firstly like to acknowledge the traditional owners of the land on which we're holding this webinar today. So in Brisbane, they're the Turrbal and the Yagara people. I wish to pay my respects to their elders, past, present and emerging, and acknowledge the important role that Aboriginal and Torres Strait Islanders continue to play in our society. As this webinar is being viewed by people right throughout Queensland and Australia, I'd also like to pay my respects to the traditional owners of the land throughout the country and acknowledge that there's still a lot to be done in terms of achieving reconciliation. So I've given my introduction of Peter, and Peter's agreed to have today's webinar recorded, so we'll put the recording up on our website later this afternoon. I've already emailed out his PowerPoints and a paper that he's drafted as well, which is fantastic that he's actually provided that for us, and I've also put them into the handout section just on the GoToWebinar control panel. So you can download those and have a look through them now or after the fact. And what we'll do is we'll hold over the questions to the end. So I will just let you know how you can ask questions. So there's two ways that you can ask questions. You can press the button that looks like a hand that you've already seen on the control panel. We'll see your hand go up at our end, and then we can unmute you so you can ask your question via the microphone. Or you can type your question into the question box on the control panel, and we'll read your questions out at the end. There's going to be a few polls today. So we've got 4 polls that we'll be putting up throughout the webinar. So please do have a look at those when they pop up on your screen and answer those if you can, because that will be really helpful for Peter. So I'm going to pass over to Peter now. So just let me share the screen there, and hopefully you'll be able to see his presentation shortly. Are you there, Peter?
Yes, I'm here.
Okay, wonderful.
Are we ready to go?
Yes, I think we're ready. So whenever you're ready.
Great. Thank you.
Thanks, Peter.
I'll just see. There we go. The happy face. Now, what I'm talking about today is Social Security overpayments and debt recovery. Now, it's a paper based on a paper and presentation I did at the AIAL National Conference in Canberra in July. And the written paper is much the same, but for the webinar, I've introduced some new material, partly because the audience may be slightly broader, and also there's some issues, particularly the issue of Robodebts is probably one of interest, and I passed over that in the conference presentation because there was just so many other people presenting about that issue that I didn't need to bang the drum as well. Now today I am talking for lawyers and paralegals. You know, I will actually mention cases and legislation, hope not too densely, but I won't be going into the really deep advocacy issues and cases, because in the end, I have a book, the Social Security and Family Law book, Family Assistance book. It's 3rd edition, Federation Press, and when you're actually preparing for a case or advocacy on this area, then you really need to go to the depth of that the book offers, rather than just some of the observations I'm making today. So, first of all, I'll just give you a little bit of an overview. See, I have not done this particular sort of project before, and I can see a poll is opened, and that poll is really just so I can get an idea of the who's in the audience. I've seen the names. I scrolled down the attendees list, but I'm just interested to know just the balance of lawyers and community sector workers. So I'm going to talk about context. Then I'm going to talk specifically about Chapter 5 of the Social Security Act. And then if there's time, and this is a bit of a moving feast, I'll talk about Part 6 of the Social Security Administration Act, which is the offences provision. And that, of course, links back into overpayments and debt recovery, because it's one of the ways they actually enforce the system, along with recovering the actual debt. I'm going to start in the context. I'm going to talk briefly about the legislative history. I think you've got to understand where it comes from to be where we are today. Then I'm going to go into the importance of language, and when I get to that, you'll understand why I'm saying it's important. There's just so many ways of manipulating the language around debt and debt recovery and overpayments that we really need to understand what people are talking about, whether they're the minister or a lawyer or a journalist. All have different language that they're using in this area. Go to Chapter 5, a fairly simple chapter in the Social Security Act, not too large, probably about 50 or perhaps a bit more sections. Going to talk about how it's a code, so it's really comprehensive. And then I'll just work through issues like the effect of the chapter that are recoverable. That's where I'll talk about methods of recovery. Oh, there's a Y missing. Look at that. You can do everything in this world and still miss typos. Non-recovery of debt moves us down into the area of special circumstances and administrative error. I'm going to talk about a new area of Social Security overpayments and recovery, which is departure of prohibition orders, which is something that people might be familiar from the Child Support Act, but now we've got in the Social Security Act, God save us. And then as I said, offences. I'll just talk a little bit about how the offences are put together. So starting with the legislative history, as always, do we have a poll result? Or I'm just wondering how I can see it here.
Yep, so we've got the results of the poll in. Sorry, Peter. I can read them out for you if you can't see them. So we've got 50%.
What do I have to do? Just click on polls, do I?
Yeah. Got it.
Oh, wow. Well, there's a lot more. It's much heavier group in terms of lawyers than I was expecting. Lawyers, small number of paralegals, and then community sector workers. But so that's good. You know, there's a really substantial number of 60%. So I will actually adjust the talk a bit because I'm talking to an audience which is a majority of actual lawyers working in this field. So you can say there's a lot of practical hands-on case experience and some other people who perhaps are less familiar with the Social Security area because they're practicing in other areas. And I think that's where the second poll comes in, just to give me something on that. Have we got the second poll? Ah, beautiful. Now I'll start going. Legislative history. As always with this area, we start with the Social Security Act 1947. Quite a simple act, about 200 sections, covered off virtually the same Social Security law as we have now. But in relation to debts and overpayments, it was literally, this whole area was covered by two sections, Section 246, recovery of overpayments, and Section 251, write-off, waiver, etc. So a real economy of language, but yet quite complex law developed in the cases from that. Now, Section 246, the recovery section, I'll read it out. So I haven't put it on the screen, but I'll read it out. Where, in consequence of a false statement or representation, or in consequence of a failure or omission to comply with any provision of the Act, an amount has been paid by way of pension, allowance or benefit under this Act, which would not have been paid but for the false statement or representation, failure or omission, the amount so paid is a debt due to the Commonwealth. Now, there's quite a number of elements there. It says it's not a debt. You may have an overpayment, but it's not a debt unless various things happen, such as it has to be in consequence of the failure or omission. There needs to be a false statement or representation. There needs to be the amount so paid. So you've actually got to link the amount of the debt back to the cause. So then there's a whole overlay of cases on this which brought forth some general principles. For example, in consequence of, there was a case that, or very cases that said that the failure or omission need not be the dominant or effective cause of the overpayment. So it's more a linkage than an absolute connection. False statement or representation or failure or omission to comply. This is not confined to knowing or intentional failures. You can also have, in a sense, willful blindness, and also this stuff about principles of administration. In relation to waiver, Section 251 just said was very broad. It gave discretion to the Secretary to waive a debt that is payable to a person under or as a result of this Act. Wow, just really clean and quick. What happened is that the full federal court in Director General of Social Services versus Hales, 1983, they gave guidance about how to exercise this discretion. Now, I haven't got the citations of the cases directly in the text, but at the end of the paper text there is a list of cases cited, plus also some references, so you can do your own study. But Hales is very important because it actually discussed this open discretion to waive, and the principles that it derived actually have informed a lot of other areas of law where there is a discretion in Commonwealth legislation to waive. For example, it informs the waiver under the Comcare legislation, though not directly. It's not written in there, but it informs people. The courts tend to go back to Hales to look for their fundamental principles, and I'll just tell you those because they set the scene for the waiver discretion when it's in fact encapsulated in specific terms. So A, the fact that the applicant has received money to which he was not entitled, and it is he. We're talking 1983. The fact that the applicant has received money to which, the way in which the overpayment arose, whether as a result of innocent mistake or fraud. So it's drawing attention to that level of severity. C, the financial circumstances of the prospective defendant, so an important sort of social consideration. D, the prospect of recovery. E, whether a compromise is offered. F, whether recovery should be delayed if there is a prospect that the circumstances of the person who received the overpayments may improve. Now this sort of interrelates with what's called write-off, which I'll talk about briefly later in the talk. And then G, compassionate considerations and the fact that the Act is social welfare legislation and any financial hardship which may result from an action for recovery. So it makes sense, the Hales principles. And the tribunal and the courts have consistently applied those principles through the whole period of the Social Security Act 1947. So it was pretty settled law. Now, the new Social Security Act 1991 came in, and it was a whopper. It was intended to have no policy change, but to rewrite the Act in plain English, and it was a bit of a problem. We turned from the 47 Act at about a couple of hundred sections at most into a 1,000-page book, and highly repetitious. But there are noble intentions, as I picked up from the DSS 1991 annual report. They had very noble intentions about what it was meant to achieve, some of which it did achieve, like an index of defined words and modules, use of tables to replace complex formulas and so on. But there were undoubtedly some really big problems, or it just wasn't very successful for a number of reasons. One is, and these are of course just my opinions, and there will be, obviously people will differ in their thoughts about this, but the introduction of plain English was genuinely welcomed. However, the drafters were less experienced in this form of drafting than is the case today. Drafters have learnt many useful lessons about plain English and the structure of legislative provisions in the 25 years since the commencement of the 1991 Act. So while we've still got a plain English drafting style, there were lessons about what not to do. The policy and drafters attempted to create an act which allows an individual beneficiary to go to the legislation on a particular payment, their own payment, and then find a self-contained statement of their rights and obligations. So if you're on, say, sole parent pension, then you go to the sole parent pension part, and it's supposed to cover everything you need to know. That's all very well, but it just didn't work because it led to a large amount of the legislation being repeated for each payment type in Chapter 2 of the Act. So you had 5 pages of procedural stuff for the sole parent pension, and exactly the same 5 pages for every different benefit, and that was it was a nightmare. It was a nightmare to work, and it was just so difficult and long that it was probably about 4 or 5 months after the Act commenced that there was actually a consolidation of it, so you can actually get a copy of what it actually was. So apart from CCH, who came out with a consolidation pretty quickly after the commencement of the 91 Act. Now, and the other problem is that the Social Security Act has been constantly and extensively amended ever since its commencement for a number of reasons, including targeting, retargeting of benefits, budget initiatives, labour market initiatives, so-called reforms. And for that reason, it was just particularly in the early days, it was just not possible to get an accurate, up-to-date copy of the Act. So the recipient had no possibility of knowing what their obligations were because you had to wade through tons of amendments, and the consolidations were rare and few and far between. Now, this is no longer the problem. This would be less of a problem now because we've got the Common Law site, and every time the Act changes, there is a new consolidation published. So IT has given us a solution to what was a recognised problem and a failed solution back in 1991. So that's all I'll say, but there's been really severe criticism of the drafting style of the Act by the Federal Court, Blunt and Cleaver, 1993, even if you see Gives. I won't go through it, it's in the paper, the things. Now, the next step is the one you see, the Social Security Law and the Family Assistance Law. Now, 2 things happened here. It was a reform of the Act. It brought in the Family Assistance Law, so it took some of the family assistance out of the Social Security Act and put it into a entirely new act called a New Tax System, brackets Family Assistance Act, and also a New Tax System, brackets Family Assistance, brackets Administration, brackets Act. So you had family assistance going off in 2 separate acts. So that was the previously under the old Act, that was family allowance and those sorts of payments. Then the Social Security Act morphed into 3 acts. The Social Security Act 1991, which kept the benefit stuff and the definitional stuff. The Social Security Administration Act 1999, which consolidated all the administration provisions so that you didn't get the repetition of the previous Act around notice provisions and so on. And it also basically combined together in one together chapters 6, 7 and 8 of the previous Act. And then finally, the Social Security International Agreements Act 1999 dealt with scheduled international agreements, and also it basically brought the scheduled international agreements into the Social Security law. So the 5 acts, the 3 acts, so 3 Social Security Acts comprise the Social Security law, and the 2 Family Assistance Acts comprise the Family Assistance law. And at the same time, this was also, of course, introducing GST concepts. The reason it's called a new tax system, brackets Family Assistance Act, is, of course, it was part of the GST package. I'm not going to talk about debt recovery under the Family Assistance Law, but it's generally the same. The two differences, which you always need to bear in mind, is that one that some of the family assistance payments tend to be done on an annual basis with reconciliation, so debts arise in different ways. And the other thing is that the special circumstances waiver in the Family Assistance Law is more basically less extensive than under the Social Security Act. But apart from that, you can sort of deal with both together in the general principles. Now, just briefly, and the paper's got a good history of this. Just briefly, I'll go through the what's happened to Chapter 5 of the Act between 1991 and 2017. Just looking at the poll results. Yeah, okay. So we've got a small group, about 11% of people who work with the Act, And then the 46, that's possibly a bit modest. Most lawyers come across this act, but only a bit. And so that's where half of the audience is. And then 31, so we've got 42% there who really, it's new to them. And I'm sorry if I'm a bit, sort of not getting into detail enough, but just go back to the paper for stuff that I'm simply glossing over too quickly. So I think the main development I want to sort of show over that time, and I won't go through all the acts and so on, is that we started with a situation where not every debt, not every overpayment was a debt. It would only be a debt if it met those particular criteria in Section 246. But as a result of amendments, between, 1991 and say 1994, we really got to the situation in the end where every overpayment is a debt. Unless they make a drafting mistake, basically, if there's an overpayment, it will be a debt. You still got to check that they haven't made a drafting error, and missed out one of the procedural steps or something. But by and large, an overpayment is a debt, and the importance of that is that it shifts the whole game to waiver, because while an overpayment may occur and it becomes a debt, that debt can be waived. So that for Social Security advocates under the 47 Act, you are often sort of fighting the good fight about it's not a debt. Under this Act, where it is now, our Act now, you're usually not saying it's not a debt, with some serious important provisos, but you are saying the debt should be waived. And there's a whole range of reasons why you can do that. There has been most recently the Budget Savings Brackets Omnibus Act 2016, so very recent, included a significant number of budget savings measures and 3 measures affecting debts, which commenced on 1 January 17. So it's just worth knowing about these because people will be probably less familiar with them. 1, the application of a new interest charge to our outstanding debts owed by former recipients of social welfare payments who have failed to enter into or have not complied with an acceptable repayment arrangement. 2, the introduction of departure prohibition orders in new Part 5.5 of the Act, and I will talk about that. And 3, the removal of the 6-year time limit on debt recovery. Probably less important than it sounds, in that there were so many ways they could get the debts back anyway. Effectively, there hasn't been that much limitation on their debt recovery, and they can recover debts right back into the 80s, and they do all the time, recovering debts over 20 or 30 years, because the 6-year limit only really applied once the debt had been discovered, had been found by Centrelink, and so a lot of these very long debts, they didn't find out that the person has had a job since the 1980s at the same time as having a widow's pension or something of that nature. So the debts may go back a very long way. So the abolition of the 6-year time limit hasn't made as significant a difference as you'd actually think from listening to it. The new interest charge, we'll see how it goes. There's been attempts over quite a long time to bring in penalty interest charges and all these things, and they bring them in and then they don't work because the debts balloon out too high, and so they stop, still in the Act, and they stop doing it. This is just another attempt, but as the Robodebt fiasco showed us, it's got teeth, that these penalty things go on. And so people who had no idea they had a debt, an alleged debt under Robodebt, because the first thing they knew about the debt was when the debt collectors turned up, they were finding they had penalty interest against them for failing to comply with the Act. So it is very significant, that one. Just pausing there, yes. I hope that this is at a level that's useful, but I'll just have to plough on because that's the nature of the webinar beast. I can't use the language of the eyeballs to tell me that I'm waving now. Where am I going? I've got to hurry. I've got to speed up. That's the clear thing. Okay, now we're going to language. I just need to see why it won't let me move. There we go. Beautiful. I'll leave that up on the screen for a while because the point I want to make is that the language is used in a very fluid way. When An overpayment, that's when you get more than the access you're supposed to have. A debt is when the legislation says it is a debt. So now most overpayments are debts, but under the 47 Act, there were overpayments that didn't turn out into debts. Error. This is the idea of that the problem was caused by Centrelink administrative error, or by a customer error, or often, in fact, most likely, a combination. Compliance activities. I tend to say that the use of the word compliance activities is a relatively neutral term. I think, you have to accept that there has to be compliance activities to support the Act. Unfortunately, there's probably not enough compliance activities to enforce the Income Tax Act. We expect compliance activities, and that word is a general term used by DHS. I say DHS because Centrelink is essentially part of DHS now, to describe its processes for prevention and identification of overpayments. So, and prevention is a good way to go. If you can actually get the regulations clear and have good systems, IT systems for running things, then you can prevent overpayments and consequently debts before they arise. Non-compliance, that's a failure to comply with a statutory obligation. It has a flavour about it of some sort of knowing or reckless conduct, but it doesn't have to be that. Non-compliance can be just pure ignorance. It can even come down to completely opaque requirements that no human being could actually understand. Now, another term that's used is serious non-compliance. Now, that's definitely got a connotation to it, and I think DHS uses that term, serious non-compliance, as a sort of a general descriptor of fraudulent behaviour or behaviour which is bordering on fraud. And then finally, fraud. That's an activity which is an offence under the Social Security law, the Family Assistance law, or criminal legislation. So fraud, in my opinion, should only be used where there is an offence or an alleged offence. Unfortunately, the use of the word fraud is so widely used, particularly by ministers in the current government, to talk about essentially about overpayments rather than deliberate fraudulent activity. A good example of how that affects us is this article in the Canberra Times. In the article, the language, there's a whole lot of language used. There's crackdown, there's compliance, there's new compliance measures, there's anti-welfare fraud effort, there's all fraud and compliance measures, there's measures delivering savings. Now, each of those words has different shades of meaning and can be applied to quite different resource expenditures and different saving targets. What's happening here is there's a headline and different people, whether it's the audit office, the journalist, the minister, saying things, and the opposition, I think, they're all talking about they're talking about the same thing, but they're using different language, and it just doesn't match up. In other words, it could be explained by everybody's actually agreeing about the same thing, but they're just using different language. So you need to be precise in this game, I would suggest. And then I'll just go back to the language. But I just want to talk about a really interesting paper that Associate Professor Lisa Marriott, she's from University of New Zealand. She illustrated the relevance of language about welfare payments. It was a recent seminar that she gave here at the ANU. She described variations in language used in this context of social welfare and taxation in New Zealand, where, quote, benefits fraud totaled 24.17 million New Zealand dollars, benefits fraud. And that's in 1415. Whereas tax fraud in the annual report was described euphemistically as tax position differences. They totaled 1.2 billion. So what we have is social benefits fraud, namely Social Security fraud, totaling 24 million, and tax position differences, and that is pure tax avoidance. That's fraud. That's not clever accountants and all the rest. This is bottom of the hardware stuff. Is 1.2 billion. And similarly, in the question of the difference between Social Security and taxpayers and social welfare recipients in New Zealand. In 2011-12, Inland Revenue wrote off 435 million of tax debt. Now, that's 54% of all penalties raised under the Act, and 11.6% of all debt. Whereas the Ministry for Social Development wrote off $6 million New Zealand of social welfare debt. That's 435 million waiver against $6 billion. Now, the reason for that fundamentally is that when the tax office comes across debt, it negotiates with the felon to get a recovery of some amount. They reach a deal. You manage to steal 30 million in tax. If you pay 5, then we'll all walk away and make a commercial settlement of it. They don't do that for Social Security, do they? They don't come down and negotiate your overpayment and say, how much, let's do that. And I think that leads me to slide 7. I'd just be interested to see what people's experience is of this issue of the different treatment of tax and tax fraud and Social Security fraud, or for that matter, tax debt and Social Security debt. Now, I'll move on from the language to the next whole part of my talk. Oh no, the compliance. I'm going to talk a little bit, just briefly about compliance. How's that? I'll leave the figures up just so you can look at it. There's not a lot to say, except you can see the size of the issue. Interventions, reductions in payments, fortnightly savings, prevented outlays. Okay, and then the number of debts raised, you can see 15-16, 2.5 million debts, 2.8 billion of debts raised. That's about $1,000 a debtor. You probably know that a lot of the debts will be quite small. If they're very, very small, sometimes they're written off. But there will be debts of 100, couple of hundred. But in my experience, the debts do come into that sort of average. And of course, they can be as high as, in extreme cases, 80,000 to about 150,000 for something that's been going on for a very long time. Just looking at the figures, there is another figure. It's not on the screen, but it is in my paper. And that is the amount of debt that is collected by commercial debt collectors on behalf of the department or Centrelink. And the figure is they're collecting 144 million out of 1.54 billion. That's 9.4%. Is actually collected using commercial debt collectors. When I talk about robo-debts, you'll start to see the significance of that. So about 10% of debt is actually collected to debt collectors, and that, of course, is debt that's raised where the person is no longer on payment. Because if the person's on payment, the way they collect debt is, of course, just to take it out of the current entitlement. So that 10% of debt is coming out of people who, and it's so usually sole parents, or people on New Start who were receiving Social Security and are no longer receiving it because they've gone back into employment, or in the case of sole parents, the kids are older and they're now back at workforce, but the debt's still there. Okay, we had a poll. I think we can probably see what the result is. I'll just wait and see if it comes up. Oh, Grania, my friend Grania. Yes, this is Grania is she's an expert on Social Security at Ulster University in Belfast, and has also come out to Australia as well, and hope to see her out in Brisbane early next year, and at the ANU. Now, she did a comparative study, and in the UK, levels of error, claimant and official error, outstrip levels of fraud. This is what she found. So 1.2 billion was fraud, 1.2 billion was customer error, and 800 million to official error out of benefits, 153 billion. That's a really interesting figure as you think about it. Fraud, that's quite a large amount for fraud, 1.2, but the same amount is customer error, and there's almost, relatively similar is actually mistakes by the department. So it's very unfair to talk about fraud and debts as being the same thing when a significant proportion of the debt is actually caused by Centrelink DHS itself, and another very significant proportion of this is error, not not in any sense misappropriation. Now, and she talked about Australia. The combined figures for error and fraud is 536 million out of 87 billion, of which 113 is fraud. So again, that's relatively consistent with the UK position she talked about. Yeah, so that's just interesting. And we'll just see if we've got a result of poll. Do you think there's... Okay, nothing surprising there. So, you know, half of you are... now, some of the people are saying it's really not, I'm not in a position to make a judgment. That's quite... but there is... Actually, I'm trying to see what those last two ones are. So, Social Security, more serious. Yep. It's interesting that a small proportion of the group, 7%, actually thinks that there is more serious action in relation to tax evasion. It's not been my experience in practice, but thank you. But I think it's just one of these things where we've got to just work from our own experience. Okay, let's move on. Okay, Chapter 5. I have to race to this, obviously, but I just want to understand. Chapter 5 is a code. It's been determined was a case in the full federal court. But the importance of that is that that debts can only be raised in accordance with the Social Security Act. They can't go off and invent new methods of either new methods of raising debt or new methods of collecting it. They're stuck with the Act, and they want to change the way the rules work. They've got to amend the Act. They can't just use common law sort of rights and recovery. Okay, so I'm going to go through the code itself. There's a part 5.1, just a small point. Part 5.2, what's recoverable under the Act, and I talk about data matching, and then I go to the Robodebts. Methods of recovery, I probably won't talk about that very much. I doubt I'll have time to get to bankruptcy. And the non-recovery, I do want to talk a bit there because it's very important, the non-recovery area now. And departure, I'll just skim over the departure orders. So the code, that's Walker, it's in the paper, so have a look at that. Part 5.1. The reason why I've put this one up is that it actually specifies how debts can be recovered. So you've got a section like the pension loan debt raised under section 1135. Those four methods are the only methods that can be used. Now, there's a whole, right through that part 5.1, there's all the different debts there are and how they can be recovered. Almost all are the same: deductions from current payment, legal proceedings, garnishee or instalments. There's just one or two which are different. Some of the ways of collecting compensation debts is purely through legal proceedings. Garnishees have a lesser mechanism as well. Then we move on to part 2, part 5.2. Starting to get interesting here. Part 5.2. What I'll do is just take you to the legislation first. Section 1222A. I'll leave it up for just a little while. This section is important. One, there's no equivalent to it in the 47 Act. This is one of the sections that, because it's a code, has actually tightened up in the sense the way it works. But this section operates to exclude the possibility that debt may arise on a basis other than the operation of the Social Security law, or the Fares Allowance rules, or the Data Matching Act. So in other words, this is part of enforcing the code. And then the next one, this is the fundamental raising a debt thing. So subject to the section, if the payment's made, if the person who obtains the benefit was not entitled for any reason to obtain it, the amount of the payment is a debt due to the Commonwealth, and the debt is taken to arise when the person... It's a pretty broad statement of overpayment equals debt. There are some less relevant sort of exceptions, but this is the fundamental game. So that's 1.223. And then on top of that, you've got some other these are just some other ways of recovering debts. Prepayments, there's special rules. When there's an AAT stay order, there's a special rule. certain one-off, this is just collecting some one-off payments from the past. The data matching, well, that's already been mentioned. Assurance of support debts have some special frills to it. That's some quite non-beneficial frills, unfortunately. Then overpayments arising under other acts and schemes. The Social Security Act is being used to collect a variety of other debts. The VA debts, Veterans Entitlements, Family Assistance Act, the Military Compensation Scheme. So, you know, this is the statutory authorisation for this to be done by Centrelink through the Administration Act. Okay, moving on to data matching. All I wanted to say is that this is just an extract, but data matching is, I think, a really necessary and important part of compliance. And originally, the department data matched with the Australian Tax Office using the Data Matching Act, which was basically matching tax file numbers. So it gave them a very accurate match person to the, the ATO person to the ATO taxpayer to the Social Security recipient. And the Data Matching Act actually has some protections in it about procedures the department's got to follow, and they're statutory procedures. The department, Centrelink, DHS, has moved away from the Data Matching Act. In fact, I doubt they'll use it much in future, because what they've decided to do is basically to go to the Office of the Australian Information Commissioner's guidelines on data matching in Australia. It's a voluntary guideline. They say they comply, but where's the penalty? And where's the knowledge of compliance as well? Particularly when you farm debts out to private collection agencies and say in contract you must comply. God help us. We all know what happened in some of the job networks and some of the debts areas when you try to contract out obligations rather than put statutory requirements in. So THS's Centrelink is moving out of the use of that act. Other departments like the Veterans Affairs Department is going to stay with it. And then what happened with these data matching acts, data matching, is that what would happen is that when there was a match found, that a person appears to have employment or an amount from employment declared to tax and they haven't declared to Social Security, what happens is under the Act, under the Data Matching Program Act, a letter goes out which, in very neutral terms, just saying there's a discrepancy here, would you like to explain it? And when you've got a client, they come in with this letter, sometimes they've got very white faces because what they've found out is that they didn't declare that particular set of employment to Centrelink, and they are facing a problem, or they come in with a bit of a furrow in the face. What's this about? And in the old, before Robodebts, you could work through these things and sort out. On the other hand, if you had a client who was white-faced and saying, I didn't do the right thing, then of course you're moving straight into the area of possible criminal prosecution, and you've got to take a quite different line there. And my advice generally, and criminal lawyers and people working in this area may have different opinions, but my advice is you've got to be very careful. You would rarely, except with legal advice, make any admissions to the department, because you're best off dealing with them in writing, putting forward your position, and not going down and doing one of the recorded interviews at the Centrelink office. Because my experience of those interviews is that they're really looking to get the evidence for a prosecution. They're not very interested in identifying exculpatory material. So if you let your client go down to the recorded interview, they'll probably provide the admissions that are the basis for the prosecution and the ultimate conviction. Many of the convictions I see in the Social Security area come about because of what clients have said to the department, having been told it'll go better for you. We were very sympathetic. It'll go better if you tell us. They tell them, and then they've created the prosecution and the conviction. So moving on to Robodebts, I've just put up here some of the documentation you might like to work with. Carly, how's the time going?
We have around 10 minutes left, so I'm going to put up the next poll.
Okay, thanks.
Peter.
I will spend some time on Robodebts. I'm not going to get to the end, but that's fine. Chapter 2 can be next year or something. In the past, as I said, they were using the Data Matching Act, but they've decided. What happened is, of course, they started to use a different matching form, and they're actually getting something like about 200,000 discrepancies by running a data match. And in the past, they're only able to do manual investigations of about 20,000 of those. And those manual investigations would lead to the letter which either causes you to have a bit of a quizzical face or a very white, strained face. In my opinion, the system worked quite well. The letters were reasonable in tone. They didn't threaten jail, if you didn't tell them everything you knew. But what, from the department's point of view, is they were collecting discrepancy matches of a couple of 100,000 and only processing about 20,000 of them because of resource reasons, manual processing. So they came up with this Robodebt. Officially it's called the Centrelink Online Compliance System, where they simply assumed all of these 200,000 discrepancies, which were identified by an automated process, were debts. And then they issued the debt notice, or the original letter, then the debt notice, and then sent it off to the collection agencies. And there were just so many problems with this particular approach. I'll just run through some of the really bad problems, and then I'll briefly talk about where we need to go from here. But they get a good quality match between the name of the taxpayer and the name of the Centrelink client. The Ombudsman report tells us that it's a very high quality match. So they're using fuzzy search phrases and so on. But they've got an extremely poor match between the employer declared to Centrelink and the employer declared to tax. There's almost no quality control. So if the person thinks they're employed by XYZ panel beaters and they're in fact employed by 123 ABN Proprietary Limited, that won't match, because the match has to be literally the same, and so you're getting enormous amounts of false matches just on the employer name. And many of our Centrelink people, of course, they don't even know the name of the employer because they don't get wage slips. They're not told who they are, don't even get contracts. So it's a very, one big thing to write up is that, it's just not a fair match. Then the second one, which is, I think, even worse, is that what the ATO collects, or what it reports and that Centrelink trawls through, is the annual amount of earnings in a financial year and the period that the employment existed for. And I think most people have been around this system for a while will know that the most employers are not very good about putting the period of employment accurately down on the declaration, on the wage declaration at the end of the year. They'll just often put the whole year. And that match of the tax data with the Centrelink data will only work if the person receives exactly the same income for all 52 weeks of the year, and the same amount every fortnight, not changing. Now, that's a very small minority of employees. People have varying hours, they have increasing wages, they have intermittent employment, and all of that will give false data as to how much the debt is, because Social Security works out debt on the basis of fortnightly income. Tax reports it on an annual basis, and to just say an average 1/26th of the tax income just doesn't give you the right figure for a Centrelink payment, because if your income varies, then some fortnights you may not be entitled to any Centrelink, another fortnight you may be entitled to almost a maximum payment. So that is just a fundamental problem with the Robodebts system, and it's one which the department refuses to change or acknowledge. It's just unbelievable. They use an automated system to detect discrepancies. That's the 200,000 discrepancies, and they've got little or no manual quality control thereafter. So what happens is really things that are just blindingly wrong will just go out in the letter and the debt collectors. Now, in their initial letter to customers, DHS requires the customer to prove the debt is incorrect by contacting Centrelink and providing the necessary evidence. The automated system, this is my understanding of it, does not cross-check what data DHS is holding on the file about customers' employment, not even the computer records about what the person declared. So that you might put in that you worked these 10 fortnights and you earned this much, and it's gone there on your New Start declaration each fortnight. The department doesn't even check that. They just put through their grossly wrong data match figure. Because how can you do 200,000, 200,000 checks of what the person is, that would mean writing a computer system which will reduce the amount of debts we raise. Now, Centrelink in the past used its information powers to actually write to employers and say, here's our client, how much do they earn? Give us a breakdown. And they had that under compulsory powers. Now, they don't do that anymore because, after all, that would require a lot of work. So instead, they say to the client, you tell us what you earned over the last 6 years. And if you can't tell us, then the debt goes through, and then they say, prove that this is wrong. Now, that's sort of wrong in so many ways. But it's discussed it's discussed in very interesting detail by Peter Hanks in his paper, and his conclusion is that that's actually unlawful because you can't actually seek to recover a debt until the debt itself exists under the Act, and there has to be a reasonable standard of satisfaction that there is in fact a debt before you can move to recovery. They're asking you to give your employment details data from as early as 2010-11. Yet on the website and on the forms they send out to the New Start recipients, it used to say, save your employment information for 6 months. Now they want, and then 6 years later they come back and say, tell us how much you earned in 2010. Now, many of the employers have gone, they won't give you anything. A lot of it's cash anyway, and the employers will deny you were there. And of course, quietly, the website, which said 6 months, on the DHS website, it said 6 months, and quietly, without fanfare, they changed the word 6 months for indefinitely. I suppose that in the sort of the vain hope that by changing the website, you can suddenly impose 6 years retrospectivity on the obligation. I can just keep going. In fact, I will. It's a bit of a hobby horse. So you've got to have your employment records. The initial letter required you. Initial letter. It's no longer the case. The Ombudsman has fixed up some of these process problems. They required the customer to respond online virtually only, in a very poorly designed program. So if you tried to go to a contact center, a customer, Centrelink center, and talk over the counter, apparently quite a few people were pointed to the online computer and say, do it there, even though the online system didn't handle multiple employers very well. There was no number on the letter to ring. So people rang the general number and sat on it for 30 to 50 minutes, getting nowhere. The debt letters, of course, 6 years, this is up to 6 years old. So a vast number of the letters went out. For the ones that were previous clients, not current, would have gone out to an address 6 years ago. Not that many people in Australia are at the same place, certainly Centrelink recipients in the same place 6 years after they were on benefit. And of course, then a lot of people only found out when the debt collectors arrived at the door. So this is only a brief summary of the problem. It's intriguing to read the Senate report and the Ombudsman report and so on. But what's really an unhappy thing is that the government hasn't responded to this. They want the debt collection, and they're willing to put up with this very unsatisfactory system. So I think in the end, we as lawyers in the community sector have just got to have a process where we identify the Robodebts and move into constructive ways of dealing with them. The National Social Security Rights Network has some material about it, and you've also sometimes got to move into the criminal area. But it's important to help people realise that the chances of this initial debt letter actually being correct is not that high. It may be correct, it may have picked up a problem, but a great many of the debts actually don't exist or are not the amount that the debt letter states. And so we give people support there. I'll stop raving about Robodebts there, but it is an important area. So we'll move on. Where are we up to? We don't have much time, so I suppose I've got to means of recovery. I won't say much more. Deductions is the overwhelming way that they collect, of course, because it's enforceable. Legal proceedings, garnishes, they are used essentially where people are no longer on benefit, and then there's a few minor ones down the bottom there as well. Non-recovery. I wasn't going to spend a lot about this, just to make it really clear to people. This is where the action lies now. If you've got a debt, you need to work on the non-recovery side. In other words, waiver. Write-off, section 1236, is not particularly important. It's probably most relevant where people are no longer Centrelink customers. A write-off whereby the debt gets suspended for a period of time, 6 years, 6 months, or a year or something, can help people who are not on benefit and are in struggling. The real issue is the waiver power, because that gets rid of the debt forever and a day. And the waiver power actually gives rise to rights. I won't go. There is a detailed history in the paper, but but where we're up to now, it's fairly stable the way waiver works. There's a very substantial treatment in my book, which people should go to when they're wanting to work in this area. The cases dealing with the Hales principle under the 47 Act are really not that relevant anymore, because the Hales principle has essentially been legislated. In other words, if you look at some of these sections giving rise to waiver, some of them are sort of coming out of the Hales principles. For example, special circumstances, admin error, the notional entitlement. So what I'll do is just go to the administrative error. This is important because there is such a high level of error in the Social Security Administration. I pointed to figures that Grania McKeever found in her study. And those figures, they ring with me as the level of error. Just pure computer error, counter error. Loss of documents is an extremely major proportion of administrative error. They lose documents and then they say, we never received them, we didn't receive them, therefore you've got a debt, and all the rest of it. There are two restrictions on administrative error. One is if they discover the error quickly enough to fix it, then it won't be waived. That's the 6 weeks. And the other really important one is that the debtor has to receive the payment in good faith. Now, while good faith sounds, it has, the courts have given good faith a meaning. Federal court in a case called Deitcher and Prince, 1997, it means to say that that good faith is not simply you knew you shouldn't have had the money. You can receive not in good faith by sort of willful ignorance, deliberate trying to avoid getting the notice, or even just blindness, or you knew there was something wrong but didn't know what it was. So if you saw the money going to bank account and you had no good reasons for understanding that it might be something else, you made no inquiries, that won't be in good faith. But if you're going to run one of these waivers on good faith and administrative error, you need to go back to the cases and understand the way it works. Moving on quickly, just the last one. Special circumstances, an important waiver. There are some elements of it. One is that it doesn't apply if there's a knowing false statement or omission. But the word knowingly actually, essentially, it does require a knowledge. There is less. It's not a sort of it's less an issue of deemed. When you go through the cases, the tribunal, does not give a very, very enormously expansive meaning to knowingly. Right. What else can we say about it? And the full statement and representation includes omissions, of course. There is a 1998 case I report in the paper, ironically called Hales as well. French J, as he then was, discussed the breadth of this discretion. It's worth going back there. And I probably don't need to say much more than that. just have a look at the cases. And finally, I'll come to departure prohibition orders, because I think we've really got to the end of the time. And that is, they've been brought in basically, I'll go to it, sorry. What they are is they're orders from the Secretary, which simply prohibit a person from leaving Australia if they have a social security debt. If the Secretary makes such a decision, then you can appeal against it in the Federal Court or the Federal Circuit Court. It's not a tribunal review. And there is the possibility for getting a departure authorisation certificate, which allows you to leave basically because you've made an arrangement with the Secretary for repayment. That might involve a bond of some sort, actually paying the money off, whatever. There's various different ways. You can go back to the child support cases to look at how it's going to, how it works there. But it's not used an enormous amount in the child support area. The debts collected under the departure prohibition orders, 6.2 million in 13-14, 7.9 million in 15-16. So child support agencies not using it to an enormous extent. It's my guess that that Centrelink won't use it to a large extent either. There's stuff in the guide about it. Have a look at the guide, section 6.7.2.100. It's all pretty general. But I think when you look at the way it all works, when you look at the explanatory memorandum, when you look at the guide, it's clear they are going for serious issues of serious failure to comply with debt recovery. Though, as we've learned in Robodebts, when the desire for savings comes on, perhaps some idiot will, come up with the idea of let's do departure prohibition orders on everybody who's got a debt, and God will do it with an auto process, and that will create chaos in this life as people try to leave country for a few weeks to go and be with a dying parent or something. So we have to hope that it is used in a way with good judgment and not just as a blanket way of raising debt on an automated basis. And I'll leave it there. There's offences. I think probably I have to stop there because I'm sure we're up to our hour now, and I would like to give people an opportunity to put some comments through. But what I've got up here is just the sections in the Admin, in the Crimes Act, and in the Criminal Code that are mostly used for social security prosecutions. And the number of prosecutions are not high. We're talking 1,000 in a year, not much more than that. And most of them go guilty because people plead guilty, but lawyers need to be aware that quite often there's quite good defences in this area, as long as the person hasn't gone down and made every admission against their interest they possibly can in front of a tape recorder at Centrelink. Okay, I might leave it there, and I think Carly is going to open up the opportunity for comments.
Great, thank you, Peter. That's fantastic. So I will open it up for questions now. So just a reminder, there are two ways you can ask questions. You can press the button that looks like a hand on the control panel, and we can see the hand go up and unmute you, and you can ask your question via a microphone. Or the easier way, you can type your question into the question box on the control panel, and we'll read that out, and Peter can then answer. So we have one that came through a little earlier regarding appeals. So Peter, I'll just read that for you. Okay, so they had a client who paid approximately $20,000 to a Centrelink debt and was assured the matter was finalised. Then 3 days later, they received another bill for a further $4,002. So they would like to appeal that and wondering how they can do that.
Well, if they've received some assurance, that's the end of the day, and it's some idiot saying it orally without it being in writing, then that oral statement probably won't get you very far, except as a possible ground towards waiver. Like there may be a special circumstances waiver in that sort of statement. You probably won't get up with one of those compensation for debt defective administration. I'd be looking at the paperwork that creates the second level of debt. Is it different or is it the same? If they, they can sort of recalculate debt, but they have to do it, there has to be the proper written documentation. And if you reach a settlement with them, then I don't think they go back and recalculate it. absence fraud because there was a waiver there for settlements. But you need to look at the paperwork of that when they're trying to have a second bite of the cherry. Is it a new debt? Is it the previous one? How did compare the two letters? Is it oral? Is it in writing? That's what I'd say. So much of Social Security practice comes down to looking at the documents, hearing what the client's got to say, possibly FOIing the file to see what the department's got, and then learning your way to deal with it from that.
Okay, so that leads us nicely into the next question. So how important is it to FOI a file for a debt, and do you have any tips on getting what you need from the department?
Depends on the debt, but usually you would, if an FOI would be part, if it's got past the ARO, if it's at the AAT, I would definitely FOI, no question whatsoever. Perhaps if it's at the earlier stage, going to the ARO or something, you may not FOI. It depends what you need to know. But a lot of these robodebts you need to FOI because you don't know what is on the file about what the client's already told them. And the FOI may actually just tell you, well, they did declare that employer. And that will the debt will then just disappear at a rate of knots. So FOI, yes, it's a very common part of Social Security practice, law advocacy, and the department, in my experience, they're slow, but and they try to lose the paperwork. Of course, you've got to make sure they can't disown the fact they never got the request, but they do in the end do it. The other trick is, and maybe people who are doing Social Security advocacy all the time would be more current than me, but you've got to actually cast the request in wide terms, because if you keep it in narrow terms, they'll just photocopy some sort of little file and that's the end of it. It's really important to get at the electronic records, not just the paper records, because as people who work in this area know, virtually no bit of paper ever gets onto a file. You can put in your wage declarations 3 times and they lose it each time. The only things that go on file are things that are actually helpful in the department's case. So you've got to get past just FOIing the file and actually FOI the computer records. There's a computer management system called CRAM, C-R-A-M, Computer Record Access or something. Anyway, there's the CRAM system and other records to make sure you're actually getting digital records as well as print records, because the department will read down your requests as much as they can. And remember that this is a right, and generally it will not be charged. So, differently from public interest FOIs, where basically they use the price, the cost of the request as the disincentive to do it. These ones, you basically got to write under the Act for your own file, and you're not charged.
Okay, that's good. So we haven't got any more questions through. Last chance for questions if you want to send them through now for Peter to answer. So I might just give a moment for that. Peter, did you want to talk about the poll results that came through for our last poll? Just while we're waiting on questions.
What was it, 28?
That one was in your work. Have you encountered
Robodebts?
Yeah.
Passed over that. Well, that's the 28% does equate with the fact we've got a fairly high proportion of lawyers, and I'm assuming legal aid or community legal centre lawyers. So it means to say that robodebts are coming through the front door for those lawyers. 28% no, 31% only a small impact. So the 28% I would suggest are a subset of the CLC and legal aid lawyer group. And what I don't know from this is, the impression I have of the robodebts is that there are whole areas of the country that are being excluded. Like I have quite a contact with Aboriginal Australia, like the Pilbara and other areas of Australia, and these robodebts are not going out into those communities, which suggests to me that the robodebts they're picking postcodes, and also there is a requirement or an intention in the robodebts to avoid vulnerable customers. So I imagine they're using that to avoid particular customers that are known to be vulnerable, though the Ombudsman wasn't impressed with the quality of that vulnerable, working out who was vulnerable. But that's consistent. It's so about a quarter of the people, and I imagine that would be a higher proportion of the lawyers are coming across these, and they will know much better than me about the problems of the system and what to do, and be guided by the national network.
Okay. We've just got one last question for you, Peter, so I'll read that one out. Is there a monetary threshold for prosecution?
Interesting. No, there isn't. There will be some entirely private guidelines, not in legislative instruments or anything you can actually get at. The way it works is that Centrelink has to choose who to investigate for prosecution, and the way that's initiated is the dreaded letter. We think there's a problem. We would like you to come and give a recorded interview at our office. In the case of the ACT, we go to Queanbeyan and lay your life down there. So there's a decision made there as about what to look for to investigate, and there will be rules about that. It's the level of the debt is one. Obviously, the type of payment is another. That there are differing debt level, differing trigger points for age pension and for New Start. New Start is much lower than, say, an age pension. Another trigger point for referring it off to the recorded interview will be the nature of the problem. Look, if it's one of those serious social security frauds where there's multiple identities, it will go to prosecution. Go to the investigation branch, and the really serious ones usually involve creation of multiple identities or collusion with Centrelink staff, and those ones will go for investigation. And if there's enough evidence, then it will go to the DPP. But most of them are not in those categories. Surprisingly, most of the stuff that is considered for prosecution falls into two categories, basically. Non-declaration or under-declaration of income when you're on a benefit, and the other is about relationship status, not declaring a relationship status. But the actual offence that's prosecuted there is not, say, the actual you said you were single when you were actually de facto. The prosecutable offence will generally be a false declaration under the Act, and of which you said nobody else lives in your house, and that's a false declaration, and it's much easier to prosecute or to prove the falsity of a declaration as opposed to the status, the status of a person's relationship. So there are rules about what goes to the investigation office, and then I think probably that what goes from the investigation office through to the DPP is basically if they get enough evidence, and they'll put it through to the DPP on the basis that it's not our job to decide who to prosecute. And then the DPP looks at the evidence, and in some cases, if there's really, there are personal factors about the person, then the DPP will not proceed. But my guess is at the moment, and it varies also from state to state. There was a time, quite a long time ago, when we were seeing sole parents in Western Australia being jailed, actually doing jail time for a $5,000 debt, leaving the kids up in the air. Now, that wouldn't happen now in any of the magistrates' courts around Australia, and it wouldn't go to prosecution unless there were special features. But if you've got a New Start debt in the range of 5,000 to 10,000, there is a real possibility that investigation will start, and if you've had previous either prosecutions or investigations or previous debts of the same kind, that will raise the likelihood of being investigated. So it's not a hard and fast money thing. What will get you triggered for investigation is the nature of the way the debt arose, and what the debt and how much.
Okay. Look, one last question has come through, so if we have time,
absolutely, no problem.
Is that okay?
I've got time.
All right, we'll slip this last question in. So this one's around, I'll just read it out. Is there a way of forcing Centrelink to disclose documents going back to the fact that the onus to prove right or wrongdoing lies with the client? Are there any sections you can highlight?
Could you just read that again?
So is there a way of forcing Centrelink to disclose documents? Essentially, they're saying the onus seems to be on the client or the customer to prove that there isn't an error. So is there a way to force Centrelink to disclose documents to disprove that or to counter that? And are there any sections of the legislation you can highlight?
Well, you're probably relying on, first of all, on freedom of information. It depends, I think, where you are in the system. If you've moved to the AAT, even at AAT Tier 1, if you're there and you think there are documents that will be helpful, then of course I would be looking at the possibility of using the tribunal's power to subpoena, because the Centrelink can't wriggle off the hook that way. It's very hard sometimes to get documents out of the department because you don't actually know what's there. And often the documents you think would be there, because you actually hand them over the counter, they're actually not there. They've gone, for whatever reason, they've disappeared. So I wouldn't say that the Act gives you an enormously strong ground for marching into Centrelink and saying, you must give me this document. But the process of the appeal process itself does. With the Robodebts, it's rather interesting how that's going to turn out, because they are asserting a debt on the basis of information which is very rudimentary. An absolutely appalling quality data match with the ATO is the only thing they have. They don't do anything else except to get that. And so, as Hank says, there's a real question as to whether there is even a debt to be pursued. But unfortunately, to actually run that argument, you've probably got to be in the federal court. The tribunal probably can't hear it.
Okay. All right. Well, we might leave it there. There was so much discussion and such an interesting and scary area of law, really. So we might take you up on your offer to deliver a future webinar down the track, Peter, because I think there's, just so much that you can talk about here. But for today, on behalf of everyone wildly clapping and cheering from the computers around the country, thank you so much for presenting to us and for taking everyone through and answering all of those questions that came through as well. So just a reminder again that today's webinar has been recorded, and we'll put the recording up on our website and send the link out to everyone who registered later this afternoon, together with the PowerPoints and other materials. And we might leave it there. So thank you so much, Peter. And thanks everyone for joining us.
Okay.
Okay, cheers.